Good afternoon, everyone. Welcome to PLP's Clinical Negligence case law update. For those of you who don't know us, Tom and I are junior members of the Clin Neg team in Chambers. I'm going to embarrass Tom straight away by saying that he's something of a rising star in this area, and he's got the profile photo, the boot. I hate this page of the slides. I hate this slide because Tom looks professional and dignified, and I look like a naughty schoolboy. But the new rounds of Chambers profile photos are coming up, so fear not, the new photos coming soon. Just by way of housekeeping, first of all, please do be aware that the seminar is being recorded and it will go on our website. So have that in mind if you're thinking of asking any questions or of mentioning anything about your own cases. For my part, I'm happy for you to ask questions during the talk, but we do intend, if there's time, to have a section at the end for questions and answers, and that won't be recorded, so you're welcome to ask any questions. Tom and I think that the mechanics of that are that if you want to ask a question, you can put it in the chat box, and we'll try to keep an eye on that and we'll try to answer that. We might also be able to give you permission to speak if it becomes necessary, so please bear with us if we're a bit slower than average on the technology. So far as times are concerned, we've got about 12 cases to go through. Plus some passing references to others. We don't know exactly how long will be. We intend for this to last somewhere between 30 to 45 minutes. We noticed today that the invite for this has it running until 2 o'clock this afternoon. I'm not sure how many of you actually get 90 minutes for lunch. I don't think you would thank us for taking the full 90 minutes blathering on about clinical negligence if you do. So we'll aim for something like 45 minutes. If we go short and you desperately need more CPD, then feel free to ring me. If we're going long, if we're running out of time, we might skip over some cases, but the handouts or the slides that we're about to show you, they will be sent out afterwards, so you'll be able to see them. And finally, apologies in advance if my voice gives out. I'm in a COVID household at the moment. As far as I'm aware, I've dodged it so far, but my wife and baby both have it. So if I just keel over sideways at some point, then somebody just let the clerks know and someone can tell the court on that tomorrow's case. Without further ado then, I will hand over to Tom, who's going to tell you a bit about scope of duty to start with.
Thanks, Pete. Yes, I've just put on the screen now the cases that we're going through. Some of you may have attended a fairly big conference that took place in Leeds last month, where there was also a clinical negligence case law update. We've done our absolute best to try and find some new important cases to add to those which were raised there. So hopefully not all of you attended the AVMA conference, but if you did, this will hopefully be a useful reminder of what you were told there. And if not, then you'll get all these cases anew. And we have thrown in some new ones that have happened since March, but as you can imagine, it's been just less than a month, so there's not that many. But nevertheless, you get your CPD either way. So let's crack on. So
you do, just before you carry on, Tom, someone said in the Q&A, someone has asked if anyone else is having problems with sound. Could someone just drop a note in the chat box and let us know if you can hear us okay? Yeah. Okay. Everyone else seems.
Yeah, might just be an isolated thing. The go-to IT answer, maybe if you leave the meeting then come back in, maybe that'll work. I don't know, unfortunately. If there's a persisting problem, just again, just flag it up in the chat. I suspect people will be able to keep a better eye on it than I can.
You carry on, Tom. I'll see if there's anything I can do in the background.
Okay. Cheers, Pete. Right, so first case, Khan and Meadows. This case might be familiar to you in the sense that I certainly did a clinical negligence talk or a case law update back when the Court of Appeal case came out in 2019, I believe. And effectively, the law hasn't really changed, but it's nonetheless useful to know that the Supreme Court maintained the position. What this case was is a wrongful birth case. It all surrounded the mother giving birth to a child which had both haemophilia and autism, and whether or not she could claim for the costs of raising a child with both haemophilia and autism as a result of being given negligent advice about whether or not she was carrying the haemophilia gene. So Ms. Meadows was the mother. She was negligently advised by Dr. Khan that she didn't carry the haemophilia gene. And it was accepted by all sides that Dr. Khan's advice was wrong, and that had he given that advice, then Ms. Meadows would have screened her pregnancy to ensure that her child wasn't carrying the haemophilia gene and would have terminated it, and so she wouldn't have incurred the costs of raising a child with haemophilia. But the advice was that she didn't carry the gene, so she didn't go through the testing, and she gave birth to a child with both haemophilia and autism. What happened at first instance was that the High Court gave Ms. Meadows an award of £9 million on the basis that, but for the negligence, she wouldn't have incurred the cost of raising a child with haemophilia and autism. Court of Appeal took the opposite view and said the additional costs of raising a child with autism were not recoverable, applying SAMCO. For those of you who, well, I certainly had to refresh my memory of SAMCO. I don't think I've read it since my law degree. This was a case involving valuers of property. They'd overvalued it, which meant that lenders provided mortgages above the market value for various properties. And then borrowers of those mortgages then couldn't keep up with the payments and they defaulted. In addition, the value of the property fell further due to just fall in the market. And the question was whether or not the valuers were liable for any loss of profit suffered by the lenders as a result of their overvaluing of the property and as a result of loss of profits arising from the fall in the market generally. And the conclusion was it was just for the negligent overvaluation of the properties initially. The way that the Court of Appeal dealt with it is they took a three-pronged approach to clinical negligence cases and the SAMCO principles. Firstly, what was the purpose of the procedure or advice that was allegedly negligent? Now, in this case, it was a specific inquiry about whether or not she was the carrier of the haemophilia gene, nothing else, that specific risk. Following on from that, what is the appropriate apportionment of risk? The defendant, by agreeing to advise and provide information on whether or not she was the carrier of the haemophilia gene, therefore took on the responsibility for whether or not the child was going to be born with haemophilia or not, knowing what the claimant was going to do on that advice. The claimant had assumed responsibility for all of the risks because she hadn't asked about any of the risks associated with the pregnancy. And then lastly, the third criteria, what loss would have been sustained in any event had the advice been correct? So this is the counterfactual scenario. So if Dr. Khan's advice had been correct and she wasn't the carrier of the haemophilia gene, what would have happened in those circumstances? Well, she still would have given birth to a child with autism and without haemophilia. And so on that basis, it was held that he shouldn't be responsible for that additional risk materializing. Ms. Meadows appealed on the basis that SAMCO shouldn't apply to clinical negligence cases, either in principle or as a matter of policy. I've got two slides there. I've just skipped straight over the first one because essentially the Supreme Court identified or expanded that three-pronged approach from the Court of Appeal, agreeing with them generally, but developed six criteria. And I say criteria loosely, but things that need to be followed each in turn to determine whether or not the scope of duty principle needs to be expanded in a particular area. And the reason why I've skipped this one is because I can explain to you what each question was whilst also telling you what the answer was at the same time. So the first issue is actionability. Is the harm which is being complained of actionable in negligence? So in this case, the harm was the cost of caring for a child with autism, and these were held to be clearly actionable. Second is scope, and that is a consideration of whether the duty extended, were the risks of harm to the claimant against which the law imposed on the defendant a duty of care. And in this instance, it only extended insofar as the specific inquiry made by the claimant, i.e. whether or not she was carrying that gene, not in relation to haemophilia. The third criteria is, did the defendant breach that duty? In this case, it was admitted, so it wasn't really that much of an issue. Factual causation, so as a result of that breach, did that cause the claimant the loss or the harm? Factually speaking, yes, because ultimately, had she been given that advice, she would have tested her pregnancy to see whether or not she was a carrier or not, and would have terminated the pregnancy. So there was a clear factual causal link. However, when one looks at the nexus criteria, so in other words, was there a sufficient nexus between the particular element of the harm for which the claimant sought damages and the subject matter of the duty? The answer is there was no duty on Dr. Khan in relation to unrelated risks that may have arisen in any pregnancy. It was only haemophilia, and that's the counterfactual scenario consideration again. So if the advice had been correct, and then finally, the legal responsibility. Was there a particular element of the harm for which the claimant sought damages irrecoverable because it was too remote, because there was a different effective cause, so a novus actus, or had the claimant mitigated her loss or failed to mitigate her loss when she could reasonably be expected to do so? In short shrift, no. In this case, the legal responsibility stayed with the claimant. In terms of the haemophilia, that was very clearly with Dr. Khan, but there being no other cause as to why baby would have been born with haemophilia had she been given the opportunity to terminate pregnancy. But everything else the claimant had responsibility for. The next case is Paul and others and Wolverhampton. So this is about secondary victims. So this is specifically concerned with when the negligence and the horrific events that would trigger a potential secondary victim claim are separated in time and space. The Alcott criteria, so I say the criteria, one of the elements of it, when this was the focus of this appeal in front of the Court of Appeal, was the criteria that the victim needed to be, the secondary victim needed to be personally present or more or less in the immediate vicinity and witnessed the aftermath shortly afterwards. So this sudden unexpected shock to the nervous system. And this case concerned 3 different conjoined appeals, and I've set them out there on the slide in terms of the period of time from the negligence and the sudden horrifying event much later down the line. I say much later, the final one, purchase, it was only 3 days later. And so the issue became whether or not, just by virtue of the fact that the horrifying event took place, also the negligence took place at a different time, and then a horrifying event further down the line should be enough as a distinguishing factor to exclude liability for secondary victims. So if you look at like the Hillsborough cases, the negligence and the horrifying event were somewhat combined, or at least that was the view taken in the Court of Appeal. So yes, part of the main issues for the claimants was the case of Taylor and Novo. I deal with it on the next slide to some extent, but effectively what the ratio of that decision was that if it's not at the same time as the negligence or very close thereafter, a horrifying event that is a consequence of that negligence further down the line is not recoverable. There were other issues that were raised in the appeal. So, for example, there was the claimants argued for Paul. So there are 3 different conjoined appeals. The claimants in Paul tried to argue that the damage for a secondary victim claim to materialize, didn't materialize until the horrifying event occurred. And so it should be seen as one event, whereas the defendant argued that the damage necessary for a secondary victim claim had to arise from the damage from the primary victim in the initial aftermath. That was given fairly short shrift by the Court of Appeal on the basis that this would lead to lengthy, unworkable and unprincipled investigations as to when the damage to the first the first primary victim stopped and when the secondary victim started. And it wasn't really supported by any of the authorities to date. And I think they described it distinctions without a difference. So it's really focusing more on instead the Alcott criteria, particularly that one that I mentioned before about whether or not they were personally present or in the immediate vicinity witnessing the aftermath. The Court of Appeal in Paul and others basically felt that they were bound by Novo. Novo wasn't it was a personal injury case. It wasn't a clinical negligence case. In that case, the claimant's mother had sustained a head injury at work. I believe some roof rafters fell on her, and she also sustained an injury to her foot. Subsequent to that, she developed DVT and a pulmonary embolism, which proved to be fatal, and she died 3 weeks later. The claimant, her daughter, only witnessed the event or the death, so the second horrifying event. The first one arguably was also a horrifying event. And the Court of Appeal held, strictly applying the Alcott criteria, that this was not recoverable because they were separated in time and space. I've set out there in the slide what Paul and others, they summarised the rationale at paragraph 91 of that decision. But in short, only psychiatric injuries arising from the immediate aftermath rather than all consequence of the negligence are recoverable. Extending it beyond the immediate aftermath in the Court of Appeal's decision in Novo would be taking the principle too far. I should say that the Court of Appeal were somewhat reluctant to be bound by the decision of Novo, but felt they were bound nonetheless. So it's unsurprising that they gave permission to appeal it to the Supreme Court. So the decision is very much TBD in terms of whether or not this is actually going to be a permanent decision. They gave the example in the hearing about if you compare the situation of an architect who negligently designs a bridge, and many years later, someone who is crossing that bridge sustains injury when it collapses. You wouldn't hesitate in those sorts of cases to say that the negligence or the tort of negligence crystallizes upon the damage being sustained. But it wasn't entirely clear why it should be different for secondary victims. So anyway, that one's a TBD decision. And I suppose the takeaway from that is if you've got any secondary victim claims where that is the key issue, whether or not the negligence and the horrifying event are separate, which I suspect will happen quite often in clinical negligence cases, then perhaps ask for a stay if it's in proceedings, and so that you can await the outcome of this decision. I'd also recommend that you read Sophie Watson's article. I put a link on it there. She's one of our pupils at the minute, so she's done a much more comprehensive analysis than I've just done. But yes, you can have a look at that as well. Next case is about causation. It's an interesting case, and it's a case of Trailer. This was involved a man who suffered from psychosis. He was discharged from secondary care, discharged from a community treatment order, and was in a property with his daughter, the second claimant, and his father. And unfortunately, he suffered a psychotic episode. The trigger for that was that he stopped taking his oral medication when he was at home, which resulted in him stabbing his daughter and the police being called and him being shot by the police. This all happened at the same time. So the police arrived, they approached the first claimant's father, and first claimant thought that they were going to attack his father, and so his reaction in his psychotic state was to then stab his daughter, and then the police shot him. So it's quite a tragic set of circumstances. Fortunately, both claimants survived. They both brought claims, but for the purposes of causation, I'm focusing on the first claimant's claim, which was he was alleging that the defendant had not adequately risk assessed the possibility that he would stop taking his antipsychotic medication. When he was an inpatient, he was being given injections, it was being controlled. When he was out in the community, it was oral antipsychotic medication. Similarly, he said that they didn't adequately advise him to continue taking his medication. But for that, he says that he would have continued taking the medication, and therefore he would have avoided the incidents leading to injuries to both him and his daughter. The defendant denied liability, breach of duty, and in any event, claimed that the first claimant was the cause of the acts by basically deliberately choosing not to take his medication. So as I said, this is a case which is more important about causation. So the claim failed on breach of duty. Court preferred the defendant's evidence as to whether or not the advice given was reasonable, or whether or not it had been as comprehensive as the claimant would have liked. But nonetheless, Mr. Justice Johnson made the following comments on causation, factual causation. He concluded that even if he'd found for the claimant on breach, in any event, the first claimant would have actually continued to take his medication. He'd made it very clear that he wanted to come off that medication. He felt it wasn't working. And so in reality, even if there wasn't any negligence, even if he had been given the appropriate advice, he still would have stopped taking the medication and the event still would have occurred. More interesting point is on legal causation. So the argument that the defendant made that effectively he had deliberately chosen not to take those pills and effectively was the author of his own misfortune. That was given, again, fairly short shrift, relying on the case of Gray and Thames Trains, where basically it affirms that defendants are generally not liable for the deliberate acts of claimants or third parties, but they will if the act was itself a consequence of the defendant's breach of duty. So what Mr. Justice Johnson is saying there is that effectively had he found that there was a breach of duty in the advice given regarding the medication, and in turn he would have that would have prevented the events occurring. In any event, the defendant couldn't escape liability on the basis that it was a deliberate act on the part of the claimant. It would have arisen as a result of their own negligence. It went on to consider contributory negligence as well, and there would have been quite a hefty deduction from the claimant. He indicated it would be in the region of 75%. It's quite an all-encompassing claim. There were also claims made by the second claimant regarding the Human Rights Act, which I don't have time to go into, but it is an interesting case to look at. I've also mentioned there that the case of Thorley and Sandwell. So this is a case on material contribution, which I'm not going to touch with a barge pole in a law with lunch because it's far too complicated to go through. And better still, fortunately, someone else in our chambers has beaten me to it. Andrew Axon, if you were at the ADMA conference, gave a presentation where he basically summarized the case law on material contribution and where we are at the minute. The conclusion, as I understand it, is that, as was summarized in Thorley, it is an area which is ripe for authoritative review. And I've put a link there to Andrew Axon's detailed guide on material contribution. So if you've ever got one which is a case which is considering material contribution, have a read through that. In Thorley, it was about whether or not warfarin would have prevented a stroke, and whether or not the fact that it was an indivisible injury, whether or not that meant that it was still, it could apply in theory. The answer was no, it was bound by Court of Appeal precedent. Next case is consent and alternative treatments, another High Court case. So the case of Malik was in relation to a failure to offer non-surgical treatment for quarter equina compression. The claimant had been suffering from back pain for about 2 years, and in 2014 he underwent MRIs where they identified the quarter equina compression. He undergoes emergency surgery. No complaint raised in respect of that, but unfortunately, nevertheless, the symptoms persisted, and further MRIs led to the defendant offering or recommending further surgery. Again, there were no criticisms of how that surgery was performed. However, the claimant suffered an incomplete paraparesis and was wheelchair bound. what the claimant was complaining about principally was that reasonable alternative treatments such as nerve root injections and pain management should have been offered. The defendant's experts disagreed and said the options were not reasonable. They would be transient at best. There was also an argument about factually whether or not the claimant would have actually elected nerve root injections and pain management when, particularly if it was only going to be a transient benefit. The claim was dismissed. I've put in there quite a significant quote from, it's on just Blair QC, effectively preferring the defendant's evidence. When he looked at the Montgomery test as to the reasonable, taking reasonable care to ensure that patient is aware of any reasonable alternative treatments, it was how we define reasonable alternative treatments. In short, the answer is that is pretty much subject to the Boland test and subject to logical analysis, Blytho. So in short, and by preferring the defendant's evidence and saying that the transient benefits given to pain management and nerve injections, it wasn't a reasonable alternative. He accepted the defendant's evidence at that point, and therefore the Montgomery informed consent principle didn't extend in that particular instance. They'd given advice on the reasonable alternatives, but it just happened to be that surgery was the most reasonable. As I say, in this one, it was also held that had he been given alternatives such as pain management, ultimately the claimant would have elected the surgery in any event, and so it wouldn't have made a difference. I've also mentioned there's the Scottish case of McCulloch. Similar situation. It was regarding whether or not an echocardiogram and non-steroidal anti-inflammatories should have been provided. Pretty much just confirms the same conclusions reached in Malik, that it's still identifying what reasonable alternative treatments are. It's subject to the Boland and Blytho principles. Non-delegable duties. So this one, again, another recent one concerning a dental practice. This one particularly going to be relevant for anybody who is suing dental practices or GP practices, as opposed to NHS trusts. In this case, the claimant was a patient of the defendant's dental practice. She was treated by 4 dentists, none of which were the defendant, but 3 of whom were self-employed. The 4th was employed by the defendant, and effectively there was they'd conceded liability in respect of that employee on the basis that they were vicariously liable for their negligence. But in terms of the other 3 self-employed dentists, the defendant denied that he was liable on the basis that they each had their own indemnity cover and were responsible for their own work. The claimant argued, by contrast, that the defendant owed a non-delegable duty as she was a patient of the practice, not a particular dentist. So when she signed up a treatment plan, she hadn't indicated or signed up to any particular dentist. She just simply signed up with the defendant's surgery, and then she was allocated a dentist who was ever available on a particular day, and that those dentists would choose which patients they would treat. It was held that the defendant had owed a non-delegable duty. The criteria was applied from the Supreme Court case of Woodland in 2013. And I've set them out there. Effectively, the claimant was a patient, person dependent on the defendant for protection against injury. The defendant was effectively allocating her case, opened up to these third parties to perform the dental treatment. There was an antecedent relationship between the claimant and that was independent of the negligence itself, namely that she had signed the treatment plan with the defendant, not with any of the other individual dentists. The claimant had no control over how the defendant chose to perform its obligations under that treatment plan. She couldn't control, for example, which of the dentists were going to treat her. The defendant had delegated to a third party some function which was integral to an integral part of the duty the defendant had assumed towards her, and it was negligent. The third party was negligent, and so on that basis, applying that criteria, it was clear that the non-delegable duty was owed by the defendant, and she was successful. Notwithstanding the fact that the claimant was successful on the non-delegable duty point, the court went on to consider whether or not the defendant was vicariously liable for the self-employed dentists, and ultimately found that he was not. Basically, the relationship was not akin to employment. So they had, for example, the opportunity to go work for other dental practices. They could choose when to work and what cases to do, or what patients, I should say. And look, we have another helpful summary, an article there which you can click on by Abby Telford this time. So when you get the slides, if you want to have a bit more of a detailed analysis of Hughes and Rattan, then just click through to that article. The last one that I'm going to talk to you about is Milner and Barchester homes. This one is probably most relevant to anybody who's doing an inquest arising from care home related deaths and potentially a clinical negligence claim arising out of that. So this involved an elderly woman by the name of Elsie. The claimant, Milner, was her friend. The allegations were quite startling in terms of quite long-standing neglect, basically being left for long periods of time in an unsanitary state, without food, going hungry, going thirsty. And to the point where the CQC had investigated the defendant and found that it had been neglectful, and found put the deceased at an increased risk of harm. So you can imagine the claimant solicitors, when they see that kind of report, they think, well, clearly we're onto some form of a winner here, because if the CQC has come in and given that much of a damning review, this should be a nailed on case. I should say this is a summary judgment application, so it's only that aspect which has been considered in the High Court. There were multiple claims, principally Article 2 and Article 3, but I'm focusing on Article 2 for today's purposes. The claimants alleged that the defendant had breached its Article 2 duty to protect life. Systemic failings on the basis of poor record keeping, competency checks, lack of training. They argued, for example, that for those of you who do a lot of inquest work, Lopes de Sousa in Portugal, that was the criteria for systemic breaches in terms of medical cases, which is quite strict. Basically, effectively, that the systemic failing has to deny access to emergency life-saving treatment. The claimant argued that that didn't apply in care home cases. It was not strictly a clinical negligence or a medical case. And then operational failings, not adequately assessing claimant's risk of choking or making appropriate referrals to specialists. So she died from pneumonia. And so the allegation was that she died as a result of aspiration pneumonia. And so that was a risk, a real and immediate risk to her life. And the defendant should have taken reasonable steps, reasonable measures to ensure that her risk or her right to life was protected. And the defendant applied for summary judgment on the grounds that, amongst other things, that the criteria for breach under Article 2 were not met. Master Davison found for the defendant on the Article 2 points. It's not entirely clear from the judgment as to why the systemic failings argument didn't succeed. I can understand why, but it's not clearly addressed in the judgment, save for saying that there was an insufficient causal link between the alleged failings and the death, but it presumably ties in with the operational failings. The risk in this case was of choking, and it was described as a medium risk. Master Davison considered that that did not meet the threshold for a real and immediate risk to life. It didn't meet, in his words, the high threshold that was set in the case of Rabone. I'm not entirely sure if that's necessarily right, on the basis that in Rabone, for those of you who are familiar with it, that was an Article 2 case concerning the death of a psychiatric patient who was a voluntary inpatient, where the risk of suicide in that case was held to be between 5 and 20%, so it was low to moderate. And the key element, in according to Baroness Hale in any event, was that the risk was significant and substantial. So I don't think the fact that it was referred to as a medium risk is enough to say it wasn't significant and substantial, but perhaps the distinction is this was a risk of choking as opposed to a risk of death, although the two are clearly linked. The other issue for the claimant was that the deceased had resided at the defendant's care home for quite a significant period of time. And so that undermined their argument that this was a real and immediate risk. And similarly, Master Davison considered that expanding the duty to include such risks, such long-term risks, would create an undesirable burden on the state. So if you imagine the number of care home residents who have got a risk of choking just by virtue of dementia or just general disability, it would encompass Article 2, it would extend Article 2 exponentially. And so they were very keen to avoid that. And lastly, there was insufficient evidence to support perhaps the key point in the claimant's argument that the claimant had died from aspiration pneumonia, i.e. so that they choked and then inhaled the whatever contents that she'd been chewing. And as a result of that, it was just simply, there was no evidence to say it was aspiration pneumonia as opposed to any other form. And so they couldn't establish that there was a clear link between the failure to risk assess her choking risk. Other aspects of the case that were considered that I'll mention just very briefly, locus standi, so whether or not the claimant, just by being a friend, was enough to be classified as a victim of the Human Rights Act. In short answer, the short answer is yes, she was, effectively as a mother-daughter relationship in many ways. And in terms of the Article 3 claim, that was allowed to proceed, most likely because of the findings of the CQC report. And so that aspect was not struck out, it was just the systemic failings. Right, I think I've gone on for far too long, but there you go, Peter, it's your turn.
No, not at all. Thanks, Tom. I'll go through my cases relatively quickly in view of the time, but you will, as I said earlier, get the slides afterwards, and you're more than welcome to drop me an email or give me a call if there's anything that I skim over that you'd like me to go through. The first section that I'm going to talk about is evidence. These are a series of cases about the reliability of witnesses' recollections and how they relate to contemporaneous documents. And none of these cases breaks any new ground legally, but my own view is that they are, if anything, they're more important than some of the appellate cases that we talk about, which deal with discrete and narrow points of law. And the reason for that is that if you have, for example, a secondary victim case or a Part 36 case or a lost years case, then you'll go to the authorities on that point and that will tell you the answer. But those cases are relatively infrequent and the issues are relatively narrow. But issues about witnesses' recollections and the reliability and the accuracy of contemporaneous documents arise in most, if not every case that we deal with. And so these cases repay some fairly close attention. Sheard is the first of those. The claimant in that case, he presented at his GP, and essentially the case turned on what was said at that consultation, and specifically what he'd said about the severity of his pain, his history of a viral illness, fever and dizziness, and his inability to remove his shirt. And for context, this was a consultation that took place in 2014 with the trial 7 years later in 2021. He was after the consultation, nothing substantive was done. He was rushed to hospital, found to have an epidural abscess of the spine and underwent decompression surgery and had a fairly poor outcome from that. And his case was that had he been referred to hospital earlier, as he should have been, that he would have recovered fully. The particular issue in this case, not terribly relevant for our purposes, is what was meant by the part of the defendant's note, which said that for the past 2 weeks he'd been unwell with a viral illness, pyrexia and dizziness. The question was whether that meant he was still unwell or he had been and had ceased to be unwell, which is what the defendant said. And the usefulness of the case for our purposes is what was said, or the summary that was given of the so-called Guestmin line of authority, which is in paragraphs 15 to 17 of the judgment. I won't read it all out. It repays reading if you do wish to read it. Could I have the next slide, please, Tom? Full Chris Whitty mode there.
I just wanted you to say it. Sorry, go on.
And the Guestmin line of authority is something that anyone who's dealing with these kinds of cases should be familiar with. In essence, I've summarised some of the key points there. It's an error, the courts say, to think that the stronger a witness's recollection or the more or the firmer, the more confident a witness, the more likely they are to be accurate, because memories are fluid, they're malleable, they're constantly rewritten, and when they are recalled. And the process of litigation itself can affect memories, and that's an important point for litigators who are drafting witness statements to remember, because we know what a statement needs to say in order to succeed in a way that a claimant might not necessarily know. But nevertheless, it's at the risk of stating the obvious, the witness statement is and should always be the claimant's own evidence. The best approach, say the courts, is to base findings on inferences drawn from documentary evidence, and to build on that and build from known or provable facts. But just because a symptom isn't mentioned in a record doesn't mean that it wasn't mentioned at a consultation. And similarly, patients may give different accounts at different times because they might refer to whatever's bothering them most on that particular day. In this particular case, the issues were resolved in favour of the claimant, partly, and by way of example, partly because the defendant doctor had, the judge said, wrongly recorded what the doctor had been told about the claimant's redundancy. So, for example, the note had said the claimant was concerned about redundancy, whereas in fact he'd been made redundant 7 years prior to the consultation. That, said the judge, had a bearing on the accuracy of the note and of the doctor's recollection. The next case, and this is probably the most significant of the three, is HTR. Howard Elgett, a member of our chambers, was counsel for the claimant in this case, and he and Jade Ferguson did a very helpful webinar specifically on this case. I've not included it just because it's one of ours, but rather because it's a pretty striking example of some of the issues that I'm talking about. It's made all the more striking because it was one of the, or it is, because as far as I'm aware, it's still ongoing, potentially one of the most valuable contested liability clinical negligence trials in recent years. Claimant says it's worth up to £20 million on their figures, and it turned on an extraordinarily narrow point, which was this: whether the claimant's litigation friend and the mother had, at a prenatal conversation, reported to the defendant doctor that she was experiencing reduced fetal movement. Claimant said that she had, and the defendant said that she hadn't. And nothing ultimately was done. The claimant was delivered too late, or was delivered by emergency Caesar, and had hypoxia and cerebral palsy. Vast swathes of the case were agreed. It was agreed, for example, that if reduced fetal movement had been raised, then the proper approach would have been for the defendant to act on it, and the defendant had been negligent in not doing that. The key point, or oversimplifying slightly, but the key point in the case was the note that was made after the ultrasound scan, and the note said that there were active fetal movements. And to put it in context, this is a case which was first intimated to the defendant 8 years after the appointment, and in the context of a trial which took place 17 years after the appointment. So those effectively are the battle lines. You have a £20 million case turning on whether 17 years previously, a heavily pregnant and distressed mum-to-be had mentioned reduced fetal movement or not, and in the context of a case where there was a contemporaneous note saying active fetal movements. How many of us can honestly say that that's a case that we would have run on a CFA all the way to trial? I don't know. I'm not sure that I would have done, but Howard did. And did it well with the assistance of his solicitors, because he was able effectively to take the sting out of that contemporaneous record. And the key points from this case, so far as we're concerned, are that the court can take as a starting point the proposition that contemporaneous records made by medical practitioners are likely to be accurate, but that is no more than a starting point. So you have to look at specifically at the wording of any note, and also at the surrounding issues to decide whether that note is accurate or whether it's complete. In this case, a note that said that there were active fetal movements was nevertheless consistent with there being reduced fetal movements. And the judge, sitting, I think, in his first High Court trial, did what judges often do, but did it explicitly, which is that he started with four, what he called them, foundation stones. So 4 objectively provable or agreed facts, and then proceeded from there to build up the conclusions to which he ultimately came. And the defendant's evidence was to be treated with caution because there were discrepancies about her evidence. She gave a seriously misleading account, for example, of the extent to which she'd been trained about performing ultrasounds and whether she performed ultrasounds or not. So the learning points from this case, aside from the general run through of the authorities, which is very, very helpful, are these: that there's a reminder for litigators on both sides to look very carefully at the records, because the court is likely to regard those as the starting point, but don't regard them as infallible. And so if you want to challenge, irrespective of which side of the argument you're on, if you want to challenge the accuracy of a record, you need to look at it effectively holistically and look at the surrounding circumstances to tell you whether they give you any clues as to whether the record is accurate. And when building a case, and this is for counsel and solicitors alike, when building a case, try to do so in the way that the judge is likely to. So in essence, don't start with the contentious points, start with the objectively provable or agreed points, use them as a building block, and then attempt to demonstrate from the judge from there how inexorably your case adds on those points. Freeman is the next case. I'll go over that very quickly indeed. In essence, it just deals with the inverse situation where there's an absence of contemporaneous records. In that case, the claimant ultimately succeeded, notwithstanding the judge's finding that it wasn't negligent for the defendant to have failed to record an alleged phone call. But what's helpful in more general circumstances is the run through that the court did of the authorities on adverse inferences. In effect, the court reiterated the proposition that whether to draw an adverse inference and the extent and severity of that inference depends on the circumstances of the given case. Tombs is just another case that you can look up if you need to on accuracy of a witness's recollection. In that case, spina bifida and folic acid. Damages. The case of Martin deals with the tricky issue of overlap between state-funded care and a claim for care. In essence, this was a claimant who had suffered as a result of the defendant's established negligence, septic shock, and organ failure and brain injury, resulting in severe neurological impairment. She had an extensive unrelated pre-accident psychiatric history. And as a result of that, she had a package of care which covered physical and mental needs. And she brought a claim for privately funded care. And the issue for the defendant of the court was how to avoid double recovery, because she would continue to be entitled to Section 117 funded physical care. And there was a risk that if she had a private care package as a result of the award on top of that, then she would be overcompensated. And the court essentially cut through it and said, because there's no perfect solution to this, there's no order that the judge could make to prevent a continuing to claim the Section 117 support for her physical needs. So the court said, well, the current care regime is insufficient to put her back in the position she would have been in but for the negligence, which, as we know, is the test for damages in negligence. And so the award for care was made, and the judge said, in essence, I acknowledge that there is a risk of double recovery, but it's not sufficient for me to make any adjustment to the award. So it's a useful case to deploy if you're for the claimant and dealing with these issues. It's a note of caution if you're for the defendant. Head is a case, again, like Tom's material contribution case, far too complicated for me to go into at this stage. But there's looking at if you've got a dependency or a lost years claim based on companies' dividends and so on. And it also includes a Part 36 issue. Limitation. This is a useful case as, again, Wilkins and University Hospital North Midlands, again, because it restates some well-known principles and it effectively cements a line of authority about, firstly, the date of knowledge, and secondly, Section 33. In short, this is a claimant who underwent a negligent, allegedly negligent left knee replacement in 2009, or rather the treatment in respect of an infection after that was said to have been negligent. He underwent lots of treatment after that. It was revised and revised again. And in 2012, he instructed solicitors and obtained an unsupported expert report. And he stopped pursuing the claim at that point. There's reference to him having discontinued, but in fact, he hadn't started a claim, so there was no discontinuance as such. Unfortunately, his leg continued to deteriorate, and in 2016, it was amputated. and he instructed a second set of solicitors and got supportive expert evidence in relation to his treatment and issued proceedings in 2019. And the issues in a nutshell were, what was his date of knowledge for the purposes of limitation, and if it was out of time, should section 33 be applied? In relation to the date of knowledge, it was out of time and pretty clearly out of time. The claimants, in order for time to start running, didn't need to appreciate all the details of the claim. He needed only to understand in general terms that the medical care might be a possible cause of his injury. He could hardly say otherwise when in 2012 he had been consulting solicitors and was clearly to some extent attributing his knee pain to his treatment. So he was well out of time on limitation. But in deciding whether to apply the section 33 discretion, the court said that it would be appropriate to apply that discretion and to disapply limitation because, and the key point is, a fair trial remained possible. This was not one of those cases where the delay had any effect on the possibility of a fair trial and there was little concrete prejudice to the defendant. The underlying claim was serious, and the defendant himself wasn't culpable for the majority of the delay, which was due to ill health and negative advice in 2013, and the delays by solicitors. But the learning points really from that case are, so far as the date of knowledge is concerned, take a realistic view. The suggestion that was initially made by second solicitors that the time started to run from the date of the amputation was clearly not right. But on section 33, it's not enough for a defendant to defeat that argument simply to point to delay and say, well, we're prejudiced. The court's going to expect you to point to a specific prejudice, which might be, for example, a witness having died or gone AWOL or key documents having been lost. Adarunmu is essentially a similar case, dealing with similar results, dealing with data knowledge in section 33, and also with some capacity issues and issues on expert joint statements added in. The next section is on experts, case of Baidu. I'll go over very quickly indeed, not least because it's not actually clear whether this is a 2010 or 2020 or a 2021 case. It's not clear from the report which is which, and partly because you might think that the judgment is blindingly obvious, but if anyone has a case that involves a litigant in person, it might be one to deploy. Essentially, the claimant, who by the date of the defendant's application for summary judgment was acting as a litigant in person, had experts who had ceased to act, and the defendant unsurprisingly applied for summary judgment on the basis that the claimant couldn't prove causation without expert evidence, and the court unsurprisingly agreed, and the claim was struck out, or rather summary judgment was given. You're all lawyers, you will all know that you need expert evidence in order to prove causation. I'm not telling you anything you don't already know, but if you have the misfortune to have a litigant in person case, then this might be one to deploy. And it's also relevant for defendants to know that the court will take a reasonably robust view of summary judgment applications in those circumstances. Finally, there is the case of Clark and Kalisinski and others. We again could have a seminar devoted entirely to cross-border claims and jurisdiction and choice of law issues, which is beyond the scope of this seminar and indeed beyond the scope of my expertise. But they're important cases generally, not least because, as you'll know, there's a lot of medical travel, people particularly going abroad for plastics cases, and they're done often cheaply and sometimes not terribly well abroad. This was a case, in essence, where the claimant had gone abroad in order to Poland in order to have breast augmentation and thigh liposuction surgery. The first defendant was the surgeon, the second defendant was his surgery, and the third defendant was his insurer. If you can hear my one-year-old screaming in the background, I'm very sorry about that. She's not very well at all, and she's very tired. The allegation was, and it's pretty clearly made out on the evidence, that the surgery and the post-operative care was substandard, to the extent that in fact she developed sepsis and came reasonably close to dying. The claimant brought proceedings in England in contracting and tort, and her breach and causation evidence was from a UK-based surgeon, and his conclusion, which was relevant for the issues that I'll mention in a moment, was that the care fell far below an acceptable standard. The judgment deals with a number of issues specific to this claim. So, for example, who the claimant contracted with, whether it was the surgeon or the surgery or both, and that was relevant to the third defendant's exposure and to the applicable law. But the interesting point really for our purposes is what's said about the relevance of local standards evidence. Because the defendant took the point that evidence of Polish standards was required by analogy with the package travel regulations, and that because the claimant didn't have evidence as to what the standards were in Poland, that the claim would have to fail. That was rejected by the court in pretty robust terms, essentially for three reasons. Firstly, because on the pleadings, as they were in that particular case, the defendants effectively had agreed that with the claimant's assertions that the applicable standard was the English one. Secondly, because the claimant's care was so bad in this case that whatever the Polish standards might have been, the care fell below those standards. So any subtleties that there might have been, subtleties of distinction that there might have been between local and English practice, were effectively irrelevant. But on the legal issue as to whether those foreign standards were actually relevant at all, Mrs. Justice Foster said, and the quote is on the slide, that effectively she said nothing decisive, so it's dicta and no more. But she was inclined strongly to the view that the travel package cases don't apply because the reasoning that underlies those cases doesn't apply to medical negligence cases. So although this was a fairly clear-cut case on the evidence, I don't think the issue is necessarily put to bed, not least because in the same paragraph, Mrs. Justice Foster went on effectively to cite one of the travel package cases and make the point about irreducible minimum levels of care, of standards rather. So although this is a fairly strong steer from an experienced judge that local standards aren't necessary, for my part, I'd be pretty nervous in a case that was more finely balanced about proceeding without it. That is everything that I had, everything that Tom and I had. If you have any questions, please do feel free to put them in the chat. If you want to ask them verbally, I think we can probably unmute you. If you want to ask them to us directly, our email addresses are on the screen.
I'm just going to stop the share and then I'm going to
stop recording.
Stop the recording.
Yeah.
Therefore, people don't need to